Good afternoon, everyone. My name is Jonathan Ellison. I was born and raised in Charleston, but I now work for WilmerHale in DC. And it's my honor to be a part of this symposium today with this esteemed panel next to me. We've heard a lot today about judicial independence. We've heard that it is foundational to our constitutional system, both federalism, separation of powers. We've also heard about the role that judicial selection plays in maintaining that independence of the judiciary. And then we have also just heard from Mr. Gowdy about the majesty of the law, the humanity of the law. And at this late stage of the day, we'd also like to just discuss as a panel what this all looks like in practice when judges are interpreting the law, vague statutes, contracts, whatever it may be, in deciding cases or controversies. So to discuss this, we've pulled together a panel from public service, from academia, and I'd like to introduce y'all to that panel just very, very quickly. There's more information in the brochures that everyone has, but just quickly. And I guess y'all are already well acquainted with Mr. Gowdy at this point, so I won't further introduce him there. But you've heard a little bit about Judge Quattlebaum, who currently sits on the Fourth Circuit, Court of Appeals. Before that, he was on the District Court for the state, South Carolina, and was a partner at Nelson Mullins before that. He also has the further distinction, claim to fame, of being my former boss. I clerked for Judge Quattlebaum several years ago and have since worked with him on a law review article on corpus linguistics, an interpretive tool that has started to appear in several federal and state decisions. And maybe we'll talk about that article a little bit in a bit. But kind of moving down with the introductions, we also have professors joining us today. First, we have Professor Jeffrey Stempel, who joins us from UNLV. He's published many, many articles, books, treatise chapters, but most relevant for our purposes today, he's recently put together an article on rediscovering the work of political philosopher John Rawls as a tool for judicial independence. And then last but not least, sitting right next to me to my right, we have Professor Jennifer Brobst from the University of Memphis School of Law. Professor Brobst has also contributed extensively to legal scholarship on a number of topics, ranging from the intersection of health law and criminal law to space law. But most relevant to today's discussion, Professor Brobst has also written about maintaining judicial independence in light of the inherent indeterminacy of language that appears in statutes and what we might do about that. I've already spoken enough, so I'm going to hand the mic to Professor Stempel, who has some slides just to kind of set forth the thesis of his most recent work.
And I'll try not to terrorize you with the slides here, but given and this is going to be Rawls for dummies, but nonetheless it's a political, philosophical construct that I think probably will help with a little bit of a visual aid. Rawls was all the rage when I was in law school, so perhaps I'm dating myself on that, but there were seminars on him, etc. And he's been cited something like 8,000 times in academic literature, but comparatively little in legal literature. Now that's probably a subject for another symposium, the gulf between the academy and the bench and the practice, and whether there's more to be learned from collaboration. But Rawls has faded a little bit, but I think has something to say for what we're experiencing now, or at least the decisions I want to criticize without criticizing the judge. So at the risk of oversimplifying, Rawls's approach is assume, if you're trying to figure out what the right rule of law is, and I know some of the professors might say, imagine you're on an island. What would be the civil procedure system or the contract law that you would design, etc.? Rawls says, assume you're right there at the outset, tabula rasa. You can create what you want, but you have to do it behind a veil of ignorance. I don't know if I'm going to be rich or poor, black or white, old or young, creditor or debtor. What is the rule that I would like to have? And I want to just say, I'm not suggesting that judges become philosopher kings or displace legislatures. If there's a clear command, and I'm going to pick for just a minute on the Trump versus United States case for a second, if the Constitution had said presidents are absolutely immune, end of the story. And Am I not projecting enough? Now I'm projecting. Okay. The end of the story. But to the extent that you don't have clear answers from text or history or legislative intent committee reports or something like that, you have things you have to come up with in terms of you have some discretion, if you will, in crafting the doctrine or the rule. So do it behind the veil of ignorance. Do it as if you're doing it for the first time, and consider if I were on the other side of the V, or if I didn't know which side of the V I'd be on, what would I want the rule to be? And so for that reason, it's basically a lot like the golden rule, right? Do unto others as you would have them do unto you. I would want the same rule applied to me that I'm seeking to have applied to somebody else. And I think there are times when courts sort of lose sight of that and don't think of that enough, and sometimes they're drawn too much into the notion of the parties before them and which one makes a greater case for entitlement or victimhood or stirring up outrage, and that it would be good as a matter of independence of thought to step back from that a little bit and think, well, to the extent that there's indeterminacy there, what are we striving for that's going to be an even-handed rule? And in that case, I think Trump versus United States flunks. In a sense, and I think one of the mistakes was, if you read the transcript of the oral argument, even more than the decision, the justices, or at least several of them, are really concerned about the poor ex-president being hunted down like a fox at a British hunting party or something like that, and have kind of lost the other side of that equation. What is the damage that a president can inflict on people? And is it reparable later? And similarly, when Justice Gorsuch says, well, we have to have a rule for the future, I think it's the opposite rule. You really want to be protecting the people who are going to be subject to potentially abusive presidential conduct, not just now, but down the road, and not worried so much about whether there'll be a vindictive successor after a former president, particularly with the practical rules that I elaborate more on in the article, in which it's just plain difficult to prosecute that sort of thing and to move forward, and certainly it's not nearly as likely as people thought about this. So I'm not going to necessarily pick on that decision anymore in order to try to keep us on schedule here, but I do want to suggest that bringing the Rawls perspective to the questions of immunity generally would be helpful, particularly not only the presidential immunity, but the immunity for government actors generally. Qualified immunity has been much criticized generally, and I think one way to think about it is, what's a rule that would work whether you're accused of violating somebody's rights or whether you're the person making the allegations? And in that sense, I think one can really question, do we really need to protect people from even having to answer when there are matters? Now, Mr. Gowdy, Representative Gowdy, TV star of Gowdy, gave us a very heart-rendering case that we were talking about. But then on the other side, you have George Floyd, right? Held down, strangled for 9 minutes directly, and I'll give him a chance to get after me in a minute here on this. But I think qualified immunity is subject to discourse or to objection as well. Judicial immunity, I think, is different, and I think that's an important part of judicial independence. And the part there is that the judge's decisions, even if they're rash, even if they're wrong, are subject to not usually being immediately put in place unless they're courtroom contempts, and they're usually subject to some sort of challenge, review, stays, appellate review, etc. The sort of immunity that executive actors can engage in can be irreparable, right? People can get killed in that sort of matter as well. So my vote is for no immunity generally on these things, but I think we also have to think about, what do we want to be the rule on damages caps? Your electrician makes a mistake that burns the house and kills the family, no caps. A doctor makes a mistake on the operating table, caps. Well, if you don't know if you're going to be a doctor, an electrician, or a patient, or a homeowner, it seems to me you would want a more even-handed rule that would not have what I would regard as just arbitrary limits on what the rights of recovery will be. Same with statutes of limitation or repose. Same with judicial power to decide facts. The civil procedure students, of course, know about the Twombly and Iqbal cases, right? Where the Supreme Court said, well, I'm looking at the face of this complaint, and I'm not sure, I don't think it's plausible. Well, if you didn't know whether you're going to be a plaintiff or a defendant, you might want the right to get a little bit of discovery. You might want to be heard by a jury to the extent that you can't resolve the matter on summary judgment. And so it does seem to me that that's uneven-handed as well in that sort of thing. Heightened criminal procedures should be the same rule for white-collar criminals as for blue-collar criminals, but it seems to me we see more of the rule of lenity being implied in the case of the white-collar criminals, although arguably those are malum prohibitum offenses rather than mala in se. I think if we were talking about interpretation, which we have two wonderful papers you'll have to look at when they're in the law review, would you want the rule to be strictly confined to a particular approach to statutory interpretation, whether it's plain meaning based on what the judge thinks, whether it's corpus linguistics, or would you want the court to take a broader approach and consider a variety of contextual and background factors, including things like drafting history? I think if you didn't know what you were going to be, what position you would be in and which law you'd be challenging, you'd opt for something broader. Same with how much discovery and proportionality, how much about the application of arbitration clauses and all of those sorts of things as well. So basically my suggestion is going to be that we, and I want to distinguish between Rawls in the adjudicative sense, trying to figure out a rule in the matter of adjudication, and Rawls in the policy-making sense, right? Rawls gets criticized by conservatives as trying to always lead you to a more liberal result. I think in the policy-making, you have more obvious trade-offs. We want public goods, but we don't want too high taxes. But in one area of policy-making, let's look at the pardon power. If you don't know whether you're going to be an executive or you're going to be somebody who is basically in the public at large, would you really want the executive to have unfettered pardon power? I think the answer to that is no. And when you see pardons being meted out to drug lords or to people who have contributed to a campaign or people who have bought an electronic coin that the pardon giver profits from, you see a damage to society at large. It's not as acute as in a case where somebody gets physically attacked, but it is still significant damage. And yet you've given these executives pardon power when we're supposed to be trusting our judicial system, right? We're supposed to trust the independence of judges. We're supposed to trust the due process and so on. And so my relatively humble suggestion is in this category of cases where we don't have clear commands of the legislature, where you don't have clearly established custom, practice, settled law, that there should be more willingness for courts and decision makers to step back. And I think this would apply to legislators as well. Is this a law I could live with, regardless of whether I'm the merchant being regulated or the customer buying goods from the, let's take a simple example, I'll leave it with creditors and debtors. I'd like people to pay their debts. On the other hand, I wouldn't like oppressive things where suddenly property gets seized without warning. We could come up, and I think we probably have largely in debtor-creditor law, come up with a system in which it is fair regardless of the particular position somebody's in. And that's, Rawls for dummies and what I would call the basic template on that, which is, well wired into Western society, but I think sometimes gets lost in the more technical shuffle of particular adjudicated cases. And with that, if someone will help me, I'll go back to our background on that'll be a little bit classier than my primitive PowerPoints. Thanks.
Thank you, Professor Stempel. In the meantime, I'd love to move on to you, Professor Brobst. Your most recent scholarship has talked about the inherent indeterminacy of certain language and statutes and advocated for resolving at least some of that up front at the drafting stage. I'm just hoping you can talk a little bit more about that. What does better bill drafting look like to you, and then what room remains for the courts to engage in statutory interpretation?
Sure, and it's so nice to be here. I'd like to thank Dean Hubbard and Ms. Phillips and Grant Majors and a number of you students who are going to help me with this article as it gets cleaned up. I've written something called a pragmatic approach to statutory construction. So the pragmatic is, I sort of still see myself, even though I'm an academic, as a practitioner first. I always have. First in the family to become a lawyer, first woman to have a job, honestly, a career in my family. And so I take all of this very seriously, and I care that it works and it functions. But I also have a bit of a dollop of legal theory in here in terms of pragmatism. And it might speak to you as I explain this, that I am also an affiliate faculty in the Department of Anthropology. So I care very much about what it is to be human. I care very much about language. I've lived much of my life overseas. And I came across U.S. v. Pulsifer before it got to the U.S. Supreme Court in 2024. And in the Eighth Circuit, it was discussing the statutory interpretation in the federal sentencing guidelines of the safety valve provision on whether mandatory minimums would apply to a basically nonviolent drug offender. Pulsifer was he trafficked in methamphetamine. And when he pled guilty at the time, I would love to know the conversation he had with his public defender, because he pled guilty at a time when the circuits were split in terms of how to interpret that provision and whether the safety valve list of factors would apply to him at all. And so years later, it gets to the United States Supreme Court, and he's been, some of you might say, languishing in federal prison. Others might say, well, it was not going to go his way at any point. But it was an interpretation of the words and or, and whether and means or means and at a certain point it starts to sound like Alice in Wonderland, right? At this point, and I thought, surely this won't go to the U.S. Supreme Court, and it did. I thought, how could we have not resolved this? So it gets to, for me, very much, not just the relationship between the legislative branch and the judicial branch, but the relationship between both branches and us and the public. So if statutes in particular are written in a simple, straightforward manner, it's setting the Constitution aside, but modern statutes are meant to be understandable, whereas perhaps judicial opinions less so. To the general public, how can they have written this in such a way that this man facing a federal prison sentence doesn't know what the sentencing guidelines mean? And so I began to look in two ways how this occurred at all, and I'm lucky at the University of Memphis we have a special archive of British Commonwealth treatises and case law. So for you law review students, unfortunately, if you get my article, you see a 1600s treatise. It means I was holding it in my hands, and it's the original thing. And so I went back as far as I possibly could to see how long this issue has been where these two words have been confusing or more specifically ambiguous. In other words, they're not vague. We know what they mean, but they could have multiple meanings. And does this then require, of course, the court to make that call if the legislative branch doesn't make it clear? And I finally got to the 1300s where this was becoming an issue still. It's part of the problem of the English language and the fact that we are practicing in a country that uses the English language. I can take this back to Anglo-Saxon times and the fact that the word or is actually a contraction of something similar to other or either. And if you start to see how people spoke at the time, and very few people were literate, this was spoken English and Anglo-Saxon getting into our American legal language, you see that what we created out of a multitude of Latin words, French words, Old Norse words, multiple words for or and, we have come today in 2026 to have these two little words that show up in statutes all the time because they're connected to lists and factors, and yet we have decided in a number of legislatures and courts not to cooperatively decide what they mean. So that, to me, speaks to an untoward deference to the judicial branch. So the question was raised earlier, could you have too much independence? And I would suggest absolutely. Too much discretion, of course. I could quote you Hobbes and saying, yes, it would be quite nice to have a more formal government structure, but be warned that the written word could be used by basically well-educated deceivers. We're all in positions of power. We're all effectively in the 1% to 5% in this room, and the power could be used not for good. And so with that, I noticed a distinction, just to answer your point, between Congress and state courts. And I was a state prosecutor. I've only practiced in state court. I've only done litigation. And it appeared that a few people, including, I believe, one of your professors at this law school, has noted that there's more activity in the state legislatures in creating legislative drafting guidelines, that in some jurisdictions it is required that a bill go through that so that you have more consistency. I've also found that the state courts in those jurisdictions will refer to that legislative drafting guideline to say, this is what the legislature means in this state, and so we respect that. I found no such thing at the federal level at all. And it's not for lack of having numerous people with experience and capability, but there is a lack of coordination between the two branches at that level that, for Pulsifer, ended up having very real-world impacts that could have been avoided. And it's not to say, and I think we're going to have some wonderful discussion today on how to determine the ordinary meaning of words. I think the judicial branch is exceptional at determining when words change over time, when words perhaps are inherently indeterminate, like undue, right? Undue prejudice. Or I'm the author of a treatise of Alabama crimes and defenses. There are so many definitions for the word person, as you can imagine, that changes over time. But words like and or that have purely grammatical construction, I would suggest that the legislature should take its own independence back and craft these properly with more consistency so that the judicial branch can spend more time on substantive matters.
Thank you, Professor. So I guess turning next to the judicial branch, Judge Quattlebaum, as the only sitting judge among us, I'm curious if you could enlighten us as to what judicial independence means to you and how it informs your approach to resolving cases and writing opinions.
Okay, thank you. Is this on? Can y'all hear? First of all, let me just say what a pleasure it is to be here. This is my alma mater. As Trey said, he reminded me it's 40 years ago, but even though it's been a long time, this is a great place for me. It's a place that started my career, that catapulted it. I'm so excited about what's going on here. And Grace, I appreciate the opportunity to be here today. And it's great to be here with the whole panel, but it's kind of cool for one of my law clerks to be here with me too. So it's great being here. To the question, what does judicial independence mean to a judge? Well, I don't really know how you could describe that maybe strong enough. I was thinking about it and a movie came to mind. Might not be a movie some of the younger folks in here know, but there was a movie in the early 90s called City Slickers. Does anyone recall that? Well, City Slickers, there's some guys from New York. They're having kind of disastrous family lives. They're having disastrous work situations. And they decided the way to kind of get regrounded, to get a fresh start, to go to a ranch for a couple of weeks. And it's a great story with lots of funny stuff as these, urban New York folks go out west and have their trouble on the ranch. But at one point, there's a real cowboy there who's on the ranch who leads it, and his name's Curly. And he's riding a horse with one of the city slickers named Mitch. And they actually are engaging in a deep conversation. And after a while, Curly says, "You want to know what the secret of life is?" And Mitch says, "Yeah, I really want to know." And he goes, "What is it?" He says, "It's one thing. It's just one thing. And if you get that one thing right, everything else takes care of itself." Well, then the Mitch says, "That's great. What's that one thing?" And Curly says, That's what you got to figure out for yourself. Fortunately for us as judges, the founders figured out that one thing, and it was an independent judiciary. They knew we didn't have the power of the purse. They knew we didn't have the power of the sword. They knew that everything depended on whether the public would trust us or not. And so they gave us some independence. They gave us life tenure, which helps. That's already been talked about today. And so judicial independence is crucial, but it's not just something we get through a life tenure. It's something we have to live out. We have to live out independence in the way we make decisions. And so what does that look like? How do you do that? Well, the way I think you do that is you follow the law wherever it takes you. Sometimes it takes you places where you're happy. You're like, I like that result. If I could pick that result, I'd pick that exact result. But sometimes it takes you somewhere you don't like at all. The result you have to give is something you would not have picked if you had to make that decision without the law's constraints. But you follow it anyway. Another way of saying this, to use Trey's comments from early, is process matters way more than outcome. Unfortunately, we look too much at outcome, as he indicated, but process is important. And one of the things I've thought about and learned about in the time I've been on the bench is in order to do my best to make sure I'm following the law wherever it takes it, is to actually identify tools and processes and stick to them. We're talking about statutory interpretation, and when you get a word, when you get a phrase that you don't really understand, you got to figure out what it means. One side's saying this, one side's saying that. We got to decide. And as you do that, how do you go about it? Well, some folks would say you just go with your gut, and some judges are real good, have real good guts. That's kind of a weird thing to say, but but they're good. They have good judgment. They have good experience. They have good life experience. That just kind of intuitive sense may get it right sometimes. But how do you know that your gut's not really influenced by the tendencies that you brought to the case that you might not even recognize? And how is there any transparency in that? So maybe gut's good, but maybe gut's not so good. Well, when you're talking about language, dictionaries are there. We've used dictionaries since we were young, and those are real helpful. Dictionaries can help us look at words, look at phrases at a certain time period. But, if you do some research, dictionaries have some limitations too. I mean, first, it's, an editor's summary of things. A lot went into it, but we don't really know exactly what everything was that went into that into a particular definition. And the editors may have some, just some perspective in how they do the definitions that aren't, that influence what they do. So dictionaries are good, but they have their limitations as well. Well, I found this tool that I've learned about, didn't know anything, 28 years of practice, I can assure you this never came up, and it's called corpus linguistics. Now, let me just say one thing. If you ever, want to say you're involved in corpus linguistics, you need to realize one thing, and you will forever be labeled just a geek for the rest of your life. So tell your family, tell your kids you're going to speak on corpus linguistics, and you've lost all credibility for ever being cool. But corpus linguistics is a tool that I've used in some opinions, and I believe it helps helps take me to where the law goes because it's more objective and it's more transparent. I'm just going to be real brief and explain how it works. Corpus is essentially a word for a large database. Databases have been assembled with all sorts of uses of the human language. Could be articles, could be speeches, could be books, all sorts of uses of the human language. And since they're databases of language, it's corpuses of linguistic information. And if you want to look up what something means or research it to help understand that, you can select a database that makes sense. If it's modern, they have modern language databases. If it's older, they have older language databases. If it's specialized, those exist. And there's general consensus that the databases aren't loaded or biased. At least that's my understanding, and that's my belief from what I've read. And so, pick a phrase. You would just, all you do would be search it, and then you would get a output that is that phrase in the context in which it was written or spoken. And if you read a bunch of those, you start to get a sense of how it's used. And if your interest is in ordinary public meaning, for example, what's a better way to figure out ordinary public meaning than how ordinary people used a word? And so that's a tool that I've found not to be any exclusive, any pixie dust that's perfect, but what it does is it gives me a process, and that process doesn't know whether I have a certain judicial philosophy or I have this background or that background. It just gives me data, and that data is helpful to me in doing that work. So I think in that sense it has some objectivity that takes you to the answer and isn't influenced by your maybe prior tendencies. The other thing that I think is helpful about it is it's transparent. When this measure is used, it doesn't have to be done, but lots of times I'll attach the research information to the opinions where I use it. So if, I've cherry-picked a definition, that's out there in black and white for someone to see. So, like I said, that's just, I don't consider this anything magic. I've used it in a handful of opinions. Some other judges around the country have used it. The Supreme Court hasn't used it by name, but they've kind of come close to using it as a doctrine. And to me, it relates to independence because it makes sure any prior tendencies, any biases that I'm trying to keep away from them are less likely to come into play.
Thanks, Judge. That's really interesting, as is everything we've heard so far, and I have many questions, but Mr. Gowdy, we haven't heard from you yet. I was wondering if you have any reactions to anything that's been said.
Yeah, I'm going to quote Tim Kaine, who this morning asked me a question, Jonathan, that I think you can help answer. He said, how did you wind up on a panel with 4 people who have written law review articles when you've never read one? And I don't know how to answer that. Here's what I'll tell you about judges. I've had this conversation with Judge Quattlebaum. I used the word humility. He doesn't like that word because he is humble. So he rejects the word. He thinks of it more as, I took an oath. I tried north of 100 cases to verdict. I don't know that I ever appeared in front of a judge that I thought was an active participant in terms of influencing the outcome. I got rulings I liked. I got rulings I did not like. I think it takes a special personality, a special skill set, whether it is innate or whether you can acquire it, I don't know. I'm not an anthropologist. I would defer to the professor. She used to be a prosecutor, but she seems pretty fair to me. I like the word fairness. I think I could be fair, but the law is not always designed to be fair. Sometimes the result is unfair, and it is still the faithful execution of the law. I just know this: nothing destroys the perception of a good justice system like a finger on the scale. And when you have judges that you think are outcome determinative, when you have judges that, look, it's not hard to tell the judge doesn't like your case. I mean, they're not great actresses and actors. It's not hard to tell. The question is whether they have the restraint to keep the jury from knowing that. I think it is indispensable to our survival as a republic that we have independent judges who can rule without sanction. I say without sanction, there is a sanction. It's the ultimate sanction. It's the political judicial death penalty. It's been rarely invoked. It should be rarely invoked. But if you have a judge that you think is so far outside the boundaries of propriety, there is something Congress can do about it. It's rare. It should be rare. But the fact that you disagree with a holding is not grounds for impeachment. It's probably not even grounds that the person was wrong, the fact that you disagree with it. I will say one final thing, and then I will shut up because I've never written or read a law review article. I thought that I wanted to do what Judge Quattlebaum now does. I thought that that is the pinnacle of the legal career, and it is. And then I, number one, found out you have to produce your transcript for Senate confirmation, and I didn't want to do that. But the second thing I realized is while I can be fair, I am more comfortable being an advocate. And if that is where you are, you probably don't need to be a judge. I keep coming back to the word humility. Do you know your lane? Chief Justice Toll and I may be the only two in the room who served in legislative bodies. I don't want to slight or offend anyone else if you did serve. That is a different skill set from being a judge. She was able to make that transition. I don't know that I would have been able to do it. I do know this. A neutral, detached referee, societal referee, is absolutely essential to us having another 250th birthday party.
So let's talk a little bit more about legislatures, Congress. In your keynote, Mr. Gowdy, you described Congress as AWOL. I think that sentiment is shared by many, many folks. But Professor Brobst, you talked about things that Congress or other legislatures could do to maybe take some power back from the judiciary by more clearly using language in statutes. Just kind of curious, like how this all squares. Maybe Mr. Gowdy, if you could go first, just like how does maybe is Congress indeed absent? What sorts of things will they step in? Will they step in to impeach? Will they step in to perhaps craft clearer statutes with the aid of, say, manuals? Or is there something else that Congress might do?
Well, if you have an idea, I mean, Congress is broken, and it was broken a little bit when I was there. They divvy up the ideas based on who's most at risk for losing their election. So if you have a good idea, a good legislative idea, they will expropriate that idea from you and give it to someone who needs a legislative victory. And then they will take it to legislative drafting. And most members vote on statutes that they have not read. And then we rely on the fourth branch of government, the one that our forefathers didn't mention, which is the administrative branch. That's who they rely upon through the CFR, Code of Federal Regulation. They fill in the details. Most of my colleagues didn't draft what they're voting on, and a alarming majority of them would not have read it. I will say this: I'm not an expert on statutory construction or interpretation. I would be careful for those who follow that school of thought. There are 435 members of Congress. You could have a 435 to zip vote and 435 different reasons why they voted yes. So if you are looking to the legislative record for why something became the law or what we intended, good luck. That is not the most reliable. I would just say write it the right way or go rewrite it.
Interesting. And I think it also gets to a point that some indeterminacy in statutes may be deliberate. It might be because there are 435 different opinions as to what that one word might mean. That might not happen in the case of and or, but in other cases. And so, Professor Brobst, I'm hoping you can talk a little bit about deliberate determinacy and how that kind of relates to the ideas in your article.
Deliberate determinacy or indeterminacy?
Excuse me.
Yeah. So I picked on and or because we have this recent case, but there are so many canons of construction judicially adopted or created, new ones created, and there is a kind of a rejoicing sometimes I see in the judicial branch that they are the wordsmiths. You know, that maybe it's okay. I get this sense, maybe it's okay that the legislative branch is inefficient or a little sloppy, because we know best. We're the most educated branch. We're the only branch that requires a lot of education, and I don't really feel that way, but sometimes it seems that way. But I also think there are moments when it is deliberately indeterminate and should be. There are certain words that I've been following the Grants Pass case very closely, right, and how local ordinances have criminalized clearing out homeless encampments, and because I'm from the West Coast, and some of the callousness in the decisions is there, but there's an indeterminate word in all of that, which is, what is a home? Can you burglarize a tent? Do you have Fourth Amendment rights to your tent? Right? All of these things that really aren't changes over time due to tech. So, for example, technology can change the meaning of a firearm over time, right? What constitutes ammunition? Is a 3D printed gun, does that count? Tech can change all of that, but something like a home has always been part of human experience, and I think will change based on mores and culture, and we need the judiciary to be able to reflect the community in that regard. So my article is just like, there's some low-hanging fruit here. Don't make it too easy for the judiciary to co-opt. And there was one, Reed Dickerson writes a very good legal treatise, and in the 60s he said on this and or issue, he said, please just stop using the term in legislation. You can have a little clause in the beginning to say any or all of the following terms, and you don't need and or at all. And he said, however, if you are particularly worried about a judge who doesn't quite like your stance on legislation, definitely don't use and or, because they're going to rewrite your statute.
Interesting. Sometimes, though, like Congress, legislatures may want to be clear and may want to refer to like legislative drafting manuals, guidelines. I'm curious how that might inform the types of tools that judges or even agencies might use in interpreting the language of the statute. For instance, we all know judges have many tools. Among them are the canons of interpretation. I'm wondering if those tools should inform one another, the manuals on one side and the canons on the other. How much should they reflect one another?
Just very briefly, there's no indication that any legislature cares about judicial canons of construction. There's no indication that judiciaries have cared about the legislative process that much until I started to see these state court decisions, and particularly I think it was about 1975, California created this drafting manual that just basically said what Reed Dickerson had said, is stop using and or, please. And we have 50 state legislatures, all with their own version of this, but they're starting to mimic each other a little bit, which I hope is a good sign. It's a good sign of cooperation, but also just pragmatic. And perhaps some of these legislative drafting manuals will take some hints from some of the better judicial canons as well. But I personally think that when we're talking about statutory interpretation, the guidance and the consistency should come from the legislature, not after the fact, ad hoc judicial interpretations, which is the best a judge could do at that point with all of the tools that you have, but it's just fixable.
Sure. So Judge Quattlebaum, I kind of wanted to loop you into this conversation as well, just kind of to gauge your thoughts on where like legislative drafting manuals might play a role when a judge reaches for tools to interpret a statute.
Yeah, it's an interesting concept. I mean, you know, and it kind of gets to, judges are not of all of one mind, of course, but I think most of us who get a statute, for example, to interpret would be real happy if it was crystal clear. I mean, that's great. Our job's easier when statutes are clear, but statutes are, written by human beings, and human beings aren't always clear. And when a statute represents a whole bunch of human beings, I suspect the odds of clarity go down a little bit. So we have no choice, but when cases come before us, but to interpret statutes that are unclear. So what do we do? Well, people have different views of that. Some judges think that the legislative record is important, and some give great reliance to that. I guess that could include a drafting manual. Some think the best evidence of what Congress intended is what they wrote on the page, and have a difficult time really going beyond that. If you've read my opinions, you'll see that's probably a viewpoint I adhere to, and so, because as Trey said, it's just hard when a law is passed by a whole bunch of people to say some piece of record was the reason, when it's a compromise of a bunch of stuff, gets to be hard work for the judge to do. And I think the most accurate thing is the text. Now, Congress could say, we hereby, adopt a drafting manual, and, it should be, used to construe, the words of a statute. And I'm sure we would do that. But I suspect the drafting manual's got some lack of clarity in it too. So you have lack of clarity in the statute, or you have lack of clarity in the drafting manual. There's probably still going to be some dispute we got to get to and deal with.
Certainly. And I think it's pretty well established that certain characteristics of legislation are that it's prospective, generally applicable, and that does make it especially hard to speak with absolute certainty at time zero for time immemorial. But I guess one of these tools that you mentioned and discussed a little bit, Judge Quattlebaum, is corpus linguistics. I'm wondering if you can kind of walk through an example of that, maybe from one of your opinions or another opinion, whether it's statute or contract, how you've used it.
Yeah, I'll do one. I'm sure this audience probably doesn't want to hear too much details of corpus linguistics, but this might. I'll try to be brief. But we had a case that was reported not too long ago, and it was a kind of typical business case. There was a financial services firm, and some people left that firm and started their own firm. And they had non-competes and confidentiality agreements that lawyers in this thing will be real familiar with. Well, the financial services industry, started worrying that, clients of financial advisors aren't real well served if, someone leaves to start a new firm and they can't get the information about the client, so that they had worries about that. And they adopted this document called a protocol that basically said, if you do this, 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 and this, and you leave, you don't have liability under any contractual arrangements. Well, but there was an exception for rating, and so what does rating mean? And does it mean, in this case, someone, the people who left represented like 40% of the business. So it was, a significant effect on the business for them to leave and take 40% of the business with them. And so the question became, was that or was that not rating? And we had definitions, we had a whole bunch of stuff, but one of the things that we looked at in order to do that was corpus linguistics. And it indicated in, the vast majority, if not all the examples of literature or English language using, that rating didn't refer to someone who left a firm and started another one, despite the economic impact of that. Rating referred to a third party who kind of swoops in and, and entices people to leave. And so we held that this was not rating, and that was the kind of corpus linguistics use. We went into a database. We did it at the time period that the document was drafted. The thought is, if it's drafted at a certain time, the most important time, professors write, language drifts over time. So do you use the language that it might have drifted to? This might not be an example of that. Or do you use the language at the time the contract here was entered into? We felt that the most reliable information was from the time the contract was entered into. So we used that language. We used modern language because it was relatively modern, and it helped us answer that question. It's just a tool. We have other tools, but the good thing about that tool is it was objective. It was data. If we had said, those SOBs left that, company that hired them, high and dry, which you might have thought of. I mean, you might have kind of gotten a little bit, angry at them. Then that might have slipped in your decision, but using data helped us to be, a little more objective with it.
Can I ask you a quick question? Because I haven't seen this in action, but I've been very curious about it. Does it give you alternatives? Like a dictionary gives you 3 different versions of meaning. You make some inference about priority on what's number 1, or is it a little bit like medical differential diagnosis? It's like, nope, you got this, and if I'm wrong, come back next week. They'll pick the one.
Yeah. So what you have is the actual. You're not getting corpus linguistics doesn't say, click. Here's the answer. You go click, and then you read and you decide what's the predominant way. You look at the actual use of it. Sometimes you may say it may be maybe 2 different interpretations, and say it's 55 one way, 45 the other. You may say that's not really helping me. This is just hard. But if it's 90-10 or 100%, you're like, that's really helping me inform what people mean when they use that words. Now, there's another question. Did Congress really think that way? I mean, who knows? But, we think, or some people think, that the best way to judge their intent is the ordinary meaning of what it means at the time it was written.
Jonathan, can I ask one question of the 2 professors?
Please.
I mean, you're the moderator, but one thing keeps popping into my head.
Ask away.
I'm going to leave Judge Quattlebaum out of it because he does not issue advisory opinions. But because I fly a lot, and because I follow the USC men's basketball team, I've been thinking about the 8th Amendment a lot lately, cruel and unusual punishment. I heard you say the word "and" ain't a good word. Forgive my grammar. It strikes me as being absurd that it would be okay to be cruel as long as we usually did it. So what are we to make of that phrase, cruel and unusual? Can I cure the unusuality by just doing it more often, even though it's incredibly cruel? How do you construe that phrase?
Yes, you can. And so I address that in this. The other, of course, is life, liberty, or property. You got ands and ors and all of these things. But cruel or unusual is often seen in state constitutions. Cruel and unusual, right, at the federal level. And yes, you can have a utterly horrific, according to the Supreme Court, barbaric punishment. And if they do it a lot, then so be it. It's cultural and custom. But your states might say, even if you did this once, we don't like it, right? They'll take cruel or unusual, or it's not necessarily cruel, but it's odd. Yeah.
This is, I guess, why I'm not a complete textualist. I'd want to know what the framers were thinking of the time. And I remember 30 years ago, Guido Calabrese said, well, we know they didn't like people being drawn and quartered. We're not quite sure, how much, when you move from that, where that dividing line is. But it seems to me that that's a case that's fair game. And I think even the late Justice Scalia would be with me in that he was at least a textualist on statutes, but he was more of a historian sometimes on the constitutional matters, in part because the Constitution's different than a statute. And let me just put in a quick plug too. We've kind of been drawn to talking like moths to a flame about the statutes, but there's judges interpret a lot of language, contract language, administrative rules, even the documents of letters and correspondence and all that sort of thing. And so, it seems to me that the argument about being more limited to text is stronger in the statutory context because Congress didn't enact a floor statement, obviously, and even or a committee report, but they did enact particular language and they're the sovereign giving positive law. But when you've got individuals making private deals, I think there's less concern about looking beyond just the text and finding out. And we recognize that in contract law, of course, of performance, course of dealing, usage and trade, and all these sorts of things as well. And the other thing, and I got to play the Rawls card at least once during this panel discussion. If you were in the original position behind a veil of ignorance, am I going to be the guy meting out the punishment or receiving the punishment? What would I want it to be? I certainly wouldn't want to be drawn and quartered. I wouldn't want to be tortured to death in the public square. But I could accept a rule where I'm going to be incarcerated, maybe even executed in a humane way. And I think that would be one way of looking at it, in addition to what the prevailing thought was, and not to lose sight of the fact that you've got a lot of background. These are guys who had a revolution to break away from England. Well, what were the things they didn't like about what the king was doing and how we wanted to be different would be one way I try to answer it.
So I'm glad you mentioned Rawls, Professor. I was hoping to ask a question about that too. The original position, the veil of ignorance, judges aren't usually writing on a clean slate, certainly not below the Supreme Court level. So I'm just curious how the ideas of stare decisis precedent factor into when you would have judges reach for these Rawlsian principles, and if you would argue it should happen more at the Supreme Court level as opposed to other levels.
I would think it should happen at the level when there isn't a determinate answer from our more foundational sources. If it's a clear statute that says, this, and let's take an example. You have to be 35 to run for president, right? That doesn't leave any room for doubt on it. Age limits, again, and I think the statute of limitations, they can't change, but I do think there might be room for a Rawlsian approach to things like when do you toll the statute of limitations, what counts as concealment, what counts as a continuing violation, things like that as well. And at the lower level, obviously you want lower courts to follow the law, but I'm not sure you want to run too far with the Supreme Court precedents. Let me give you at least my take on what happened after Twombly and Iqbal in 2007, 2009, respectively, which said, the pleadings have to be plausible. Well, I think you have to appreciate that Twombly was a massive antitrust case, and Iqbal was suing the Attorney General and saying basically the Attorney General knew that this guy was being renditioned, if you will, and mistreated. And those are cases where you can see why the court might have a little bit of qualms about letting them go forward. And then in Nevada, our faithful federal district judges there would take take a complaint where somebody said, I slipped and fell on wet spot in aisle 3 at the Walmart, and they'd be doing this extensive Iqbal analysis. Is this plausible or not? And there I think you'd want to think about, well, and I'm not even sure it's Rawlsian, but just, are we really going to overthink this? Right now it's an allegation of something we know happens on occasion. It's not far-fetched. It's not complex. It doesn't interfere with government function. It doesn't have massive economic impact. Why are we overthinking this, and why are we writing this new precedent, which is a departure from the traditional pleading rules to this extent? And so that's not quite Rawlsian, but I think it would be an area where lower courts have more flexibility. They don't have to be slavish to go through a high church analysis on a case that doesn't demand it.
Mm-hmm. So I believe we have about not a ton of time left. And so I just wanted to open things up a little bit. First, I guess, panel privilege, if anyone had any reactions, questions to anything else that has been said, and then to the audience if there are any questions. But first, panel.
Can I just ask a quick question of Judge Quattlebaum? How time-consuming is the corpus linguistics analysis that when you do it?
Yeah, it takes a lot of time. I mean, you gotta read all that stuff. You get a printout of, 300, 400, 500, hits.
Mhm.
You can do some sort of, some sort of, standard, maybe less than that based on some appropriate way of doing it. But it takes a lot of time. But, we to get,
Sure,
to get it right,
not-
you spend
not
time.
saying it's not worthwhile.
Yeah. I mean, so, yeah.
And if it, just a quick follow-up, and I don't know if you saw Judge Newsom from the 11th Circuit had a concurring opinion in an insurance coverage case
Yeah.
where he openly used AI and indicated his, and do you have and then in response to that, former Justice Tom Lee and Jesse Egbert, who's a linguist at Northern Arizona, said, don't use AI, use corpus linguistics. Do you have kind of a view on that?
Yeah, I'm not going to get into either one of those. I'm familiar with both that article and Judge Newsom's opinion. I mean, Judge Newsom makes the point that, that AI is the equivalent of a database, if you will, maybe a more representative database. And so it's, another way of looking at ordinary meaning. It's quicker. It's cheaper, has those sort of advantages. Former Justice Lee would say, yeah, but what it does, it just tells you the outcome. I mean, you can ask AI, what does this mean, or does it mean that? But it doesn't give you the transparency of looking at the actual sources and seeing how they got there. So they're different things. I mean, AI's, obviously everywhere. I don't want to say that's not something that's appropriate at all, but it's got some, they each have strengths, they each have weaknesses. I've not really thought long enough or hard enough to have a view on one or the other.
So maybe if
Well, I shouldn't say that. I have a strong view of corpus linguistics since I've used it. I haven't developed one on AI yet.
Although AI really likes to take from Wikipedia and Reddit, so that, so far, might be better later.
Any other questions among the panelists? Great.
Yeah, what was it like working for Judge Quattlebaum?
Best year of my life.
Great answer.
Any questions from the audience?
Hi, thank you for being here. We've talked a lot about judicial independence, but not quite a lot about the role of the appellate review process in judicial independence. So I was just wondering how you viewed the appellate review process inside of judicial independence, because on its face, it seems like it would bolster maybe overall trust in our legal system. But I think, I was wondering if you have any thoughts about the possibility of that subsequent review having any negative bearing on judges' independence at the lower levels, and should it change our calculus around what it means to have an independent judiciary?
If you want to go.
You're the only appellate judge.
I was hoping our professors would answer that, but yeah. So I'm not sure I completely understand the question. Let me try, and if I'm not getting it right, please, let me know. I think the independence of the judiciary is important at each and every level. At the appellate level, where I am, I think it's vital. At the trial level, I think it's vital. I don't think, appellate review, we have to review matters, and sometimes we review trial courts and reach different decisions. I hope and believe that we do that with the appropriate amount of appreciation. Trial judges have a way harder job than we do. They got more work to do than we do. They have less resources than we do. They have shorter time periods to make decisions. If we, and for that reason, our standard review is often abuse of discretion on lots of things. And that means even if we would have done things different, we're not supposed to review. That's not supposed to be an error. So, so if we stick to our standards review, I don't think it does anything. I don't think it's harmful to the notion of an independent judiciary. But it is important to know our role in the system. Our role is detached, and when a trial judge looks at things like witnesses' demeanor, body language, our job is not to kind of pretend we were there and would have made a better decision. We should be making most of our decisions on legal issues, and so I don't know if that's getting at the question you were talking about, the relationship between the two. But I think both levels of judiciary should display independence, and hopefully we do our job in a way that's not counterproductive to the trial courts.
We have like another minute or two. Do we have time for one more question, maybe, if there is one?
Thank you all for being here. Right now, the Supreme Court, unfortunately, has its lowest approval rating in history. And I'm just curious that, it's very hard for institutions to gain back trust once they've lost it. So is there any suggestions for other people in the judiciary, how they can continue to uphold and kind of earn back maybe the right from the people, at least, to be an independent judiciary?
Well, I'll take a stab at that just to protect my friend and classmate from having to comment. I think it'd be great if every now and again we surprise both our friends and our perceived opponents. I think it's really not good when you can predict the vote before the briefs have been filed and before there's been oral argument. So I love it when judges surprise us. Some people don't. Recently, I think someone was not happy with a particular opinion, if I read the articles correctly. I love it. There's a reason I mentioned that John Few ruled against me more than I think a judge that I didn't know would rule against me, because it mattered to him to avoid the appearance. When judges begin to treat their foes and their friends and surprise us with their unions, and let's be honest, Scalia and Ruth Bader Ginsburg were very, very good friends. I think the comedy with a T on the high court is much better than the comedy among us who are reading their opinions. I think they get along just fine. Chief Justice Toll would know better. She served on the highest court of record in our state. I like it when we don't pigeonhole people. And that's why I also said judges have an obligation too. It is episodic and rare, but I have read district court orders that sounded like it could have been a press release from my office when I was in Congress. And that's not fair to the 99% of the judges that don't talk and write like that, but you give ammunition to your critics. So surprise us with your independence.
If I could just follow up on that, let me, maybe this will be an optimistic way to kind of wrap things up. There are certainly examples of decisions that probably might have an outcome in mind before you get there. I don't want to say we're all perfect. But let me just give you two examples from the Fourth Circuit since I've been on the court. There was discussion earlier about a case out of Montgomery County, Maryland. We had a prior case out of Montgomery County on our court, and they had a policy concerning transitioning students that was very supportive, that even to the point of not disclosing that to parents. A group of parents who thought that was horrible brought a lawsuit in the Fourth Circuit. You don't know who the judges are till you get there the morning of the oral argument. In the Fourth Circuit, the judges were three judges appointed by Republican presidents that if you could have imagined maybe in terms of stereotypical who would be the most favorable judges for that case to the plaintiffs, it might have been that panel. We dismissed the case because those parents didn't have kids who were transitioning, and therefore they didn't have an injury. And so we said, if you don't like it and you don't have an injury, where you're supposed, you should deal with the ballot box rather than in the courts. So that's one. A conservative challenge to a conservative court that didn't result in a conservative outcome, at least in the way you look at it that way. I had another one with Judge Richardson, who's here not too long ago. It was a challenge to the North Carolina voter ID law. Here you have a conservative law brought by more liberal plaintiffs. We affirmed that judge. Our panel was not, had judges appointed by different presidents, probably had might have had different views about that law. We had a unanimous opinion affirming that law being constitutional. So, I just see it every day that the things that get reported on are just wrong. And I mean, so now again, there's a few bad apples can make it that way, but I mainly want y'all to not think that everything you read is true. How we solve it, how we get the word out, that's a big question, and I'm not really smart enough to do that. But what I don't want you to leave here thinking is just because the Washington Post or Fox News says something, it's right.
At the risk of wrecking what's a great summation or of no to end on, my argument on this would be to try to find things that are not particularly loaded in terms of substantive policy preferences and have the court do a better job. So, recently they amended their rules so that you can have individual stock ownership. I would ban stock ownership. I would ban getting any kind of gratuities. I don't like to see the justices show up at either the Federalist Society or the American Constitutional Association and be giving speeches. I don't like it when they go to a law and economics seminar that's sponsored where they're wined and dined by the legacy of the Henry Manny Group and things like that. And I know, judges will tell me they chafe at that. Why do I have to be so isolated? You've got a pretty powerful position there and a pretty special position in society, and some sort of restraint might be in order. And because those are all kind of neutral things, we don't show up at things that might be partisan. We don't trade in things. We don't let billionaires take us on expensive vacations. I think that would go a long way to sort of saying, whatever we decide, it's not because we felt we owed somebody or we were too palsy with somebody. I'll get some pushback on this. When Justices Ginsburg and Scalia would have their New Year's Eve party with the late Theodore Ellison, who was a prominent Supreme Court advocate, but Ted Olson's going to be arguing in front of you too. Do you really want to be that close with people? And if it's a pre-existing friendship, maybe that's different. But all of that stuff concerns me a little bit. I would like to see more arm's length things.
Thank you for the question. Thank you all for your thoughts. We'll yield the floor because we're over time, but hopefully the conversation continues.
Thank you.